You cannot actually talk about contracts without talking about elements of contracts. And also, you cannot talk about elements of contracts without talking about offer as the first element of contract. Because offer is the fulcrum upon which other contract is built. Offer is the fulcrum upon which other elements of contract proceed from. However, if this is the first time you are joining this channel and you are interested in receiving legal tutorials as well as legal updates in the field of law, we encourage you to subscribe to this channel. Now we proceed to our main agenda on this lecture video. So what is an offer? An offer is a clear, definite and unequivocal proposal made by one party, the offerer, to another, the offeree, signifying their willingness to be bound by the terms if accepted. Therefore, you could see an offer as an announcement of a person's willingness to enter into a contract. An offer may be expressly stated or be implied from the conduct of the parties. It was on this note that Lord Denning of blessed memory, in the case of Story and Manchester City Council, say that actually you do not have to look into the minds of parties to a contract for you to say that there is actually a contract existing between the parties, but rather you look at their conduct. You look at what they have written down. Then if there is absence of a written document, you look at their behavior to actually see there is a contract. So in contract law, it's not something you can say, yes, I feel like. You don't feel, but rather, the party may even deny there is no contract, but as a judge, as a lawyer, you look at their conduct. In the case of implied contract, we shall come to that. That's why element of contract is very important. Now, we can comfortably proceed to the second segment of this video, which has to do with what are those characteristics, or what are those features, or what are those condition precedents that must be in place for you to actually say that there was a valid offer. This is very important because offer didn't just end with definitions. Offer didn't just end with stating that offer is this or that. It must provide a holistic, and this is where the problem question is going to come from. The lecturer is not going to ask you a definition of offer. So now we are going to proceed to the conditions, things you are going to see in your problem question that could actually tell you there was a valid offer. Because if there was a non-valid offer, I don't think any other element of contract like consideration, acceptance will even come into play. So we are focusing on offer today. Now let us see those 8 things that have to be in place for you to actually say there was an offer. Number 1, an offer must be clear, definite and unequivocal. The offer must not be vague or ambiguous. Now I will provide you with a case that actually illustrates this. And the beautiful thing about this case is that it will actually help us to drive home our point that offer must be clear, definite and unequivocal. This case is case of Olapo Obafemi Awolowo University. The citation is before you on the screen. So what happened in this case is that the respondent, Obafemi Awolowo University, back then in that era of 19s, invited the architecture, that is the plaintiff as well as the appellant, for a particular building proposal. So the architecture, after examining the whole thing, now, after checking out the whole thing, then they made a proposal. They are going to construct a particular building within the vicinity of that school. Their proposal didn't come to conclusion, like they didn't arrive at any particular conclusion. They just maybe a kind of executive meeting or something like that. Then after they are done, the whole party left. The very architecture in question here, the plaintiff and the appellant, then went ahead to draw the plan of that particular building. He later on presented it to the respondent of Obafemi Awolowo University. And then they refused to pay. So the young man or the young architecture, the plaintiff appellant, then instituted an action in the High Court seeking to recover the money or the proposal of that very particular building which has drawn. Of course, you know that drawing a building proposal is not just an easy thing. It's something that comes with worth of money. Then the architecture then demanded the money, the particular amount for that proposal. The argument of the respondent of Obafemi Awolowo University was that there was not a contract. They just ended with their proposal. They just ended with their bargain. They are going to do this, they are going to do that, but they didn't give a go-ahead order to the architecture or the plaintiff or the appellant in this case to go ahead with that building proposal. Standing on this, they said they are not going to pay anything. Then the question before the court was whether there was actually a valid offer and whether there is actually a valid contract. Then the court of first instance, the High Court heard that there was not a contract. Then the plaintiff, being dissatisfied with these very decisions of the trial court, then took the matter to the appeal. It was on the appeal that the court took time to say that for there to be a contract, The contract must be clear, number one. It must be unequivocal. It must be unambiguous. So unequivocal simply means that there must be a go-ahead order. If you make a contract to me that you want to sell your car, I must accept it without any condition. We are going to come to that element of contract. This very case, the case of Olakpo vs. Obafemi Awolowo University, clearly shows us that for there to be a contract, so to say, for there to be an offer, it must be a clear one. It must be definite. It must be an express go-ahead order. You cannot just wake up and say there was a contract. We just discussed, maybe you presented a book to me that you want to sell this book. We didn't conclude as to how many or how much I'm going to buy this book. You went ahead and make your photocopies, or you went ahead and print as many as possible to sell to me because I'm thinking that I made the proposal. No, the court rejected that thing. So this is a very valid authority when you are talking about definite and conciseness and unambiguous of an offer. Then number 2 characteristics or conditions or requirements to a good offer is that an offer can be made to the whole world. Yes, you get that right. And the locus classicus authority to this case is the case that all law students know. It's the case of Kalili and Smoke Ball Company Limited. So the case of Kalili and Carbolic Smoke Ball Limited, a case decided somewhere in 1893, is almost a case that all law students are used to. Like, it's almost a case that no law students who have actually punctuated on law of contract could say that he has not come across. In that case, it is a locus classicus that say that an offer can be made to the whole world. What do we mean when we say that an offer can be made to the whole world? This simply shows that actually there can be an offer between you and the entire world. You know, if you have considered a video we made on the introduction to law of contract, and that is a very important video, you can check the video by clicking the link above to see to that video. That is where we define a contract as an agreement between two or more parties. It was that case we gave video. We also pointed the case of Nikitobi. We also pointed the judgment of Nikitobi JSC in case of Orient Bank and Billante International, where the learned judge defined contract as a legal agreement between two or more parties, creating reciprocal legal obligation. Yes, go and check out that video. Based on what we saw in that very video where we defined contract, the whole thing boils down to the fact that contract is an agreement between two or more people. More people here mean that it could be 3, it could be 4, it could be 5. But nobody envisages a situation whereby a contract can be made by one single person to the entire world, to the entire children of Eve, to the entire children of Adam. Nobody envisaged that situation up until 1893, where the court, the English court, in the case of this Kalili and Carbolic Smoke Ball, expanded that theory or expanded that doctrine that an offer can be made to the whole world. Now, I'll provide you with the fact of that case because it's actually an interesting case, and it was the first case I learned back then in year 1. What happened in that case is that the defendants, Carbolic Smoke Ball Company, made an advertisement in a national newspaper saying that they had a particular drug which, if anybody uses it in appropriate manner as stipulated by the leaflet of that very drug, if anybody uses it accordingly without any kind of breach, and that person caught influenza or that person catches influenza on the long run, the person will be rewarded with $100. That was a big money back then. Then, to show how serious they were, they claimed that they have made a deposit of $1,000 to an alliance bank, a particular bank back then in the Britain, that they have deposited the money, $1,000, to the effect that if anybody actually uses this product and catches influenza, that person should come to them and they are going to reward him. Because they were trying to advertise or market that drug to the effect of its efficacy. Meaning that if you have actually used that drug, you're supposed not to be caught with influenza, all those things. Then, Kalili, in good faith, then decided to test run what they have said, She then bought that very drug and used it accordingly as is stipulated. Then on the long run of using the drug, she caught influenza, or she was infected by that very cold something which the drug claimed to cure. Then he went to the company and said, look at what happened. I've used this thing as you said, oh, behold, I'm still here suffering from influenza. Please give me the money you said you are going to give me. Then they refused. The company refused. The company, for them, who are you? Who sent you here? Do you think we are Father Christmas here? We just made this thing. We are just selling our product. So please spare us this your nonsense. Get out of here. Then the young woman went to the court. He didn't even reach her home. He just decided to branch at a particular court in UK. Then he branched there and he stated an action. Then the first court examined the whole thing and heard there was a contract. The defendant, not satisfied, took the matter higher to the Court of Appeal before Justice Lidley, Justice Bowen, as well as Justice Smith. Then it was in that very case now that the full court of Court of Appeal of UK then examined the whole thing and said there was a contract. The court, I'm quoting Lord Bowen now, he stated that any reasonable person who has seen what this company, the act of this company and their proposal, would have no doubt as to whether there is a contract. And the court faulted the company on very important thing, which is the promise could have just become a mail puff, because the argument of the defendant, Carbolic Smoke Co. company, was that it was just a mail puff. If you read that case, you will see where they use the word a mail puff. A mail puff means that it was just a mail claim. It was not just a claim. It was not a claim that was actually intended to be materialized. But the court said, no. This could not be regarded as a mail claim, because according to Justice Bowen, he said, it is an offer made to all the world. And why should not an offer of this kind be accepted by anyone who fulfills the conditions? Actually, the company was faulted for not only making a promise, but making a very solid claim to the effect that they have deposited a £1,000 to a particular bank to show that they were actually mean and we are ready for business. So the court say that such a promise in this case, it is something that they are actually intended to create a contract, not only within themselves, but to the entire world. So anybody who fulfills that condition of using that very product has then met the requirement of acceptance, because the offer is valid based on their assertion. And now, this case cut across all the elements of contract. It cut across acceptance, it cut across intention to create a legal obligation, it cut across consideration. But what we are discussing today is element of contract. But if you want to see many more videos, and as well as how this case applies to all of them, go to our playlist. If that video has not been posted, depending on the time you are watching this video, I believe me, it's going to be posted. It's a matter of time, depending on where you are watching this video. If I encourage you to go there and see actually how this case applies to consideration, acceptance, and what have you, intention to create legal obligation. So we proceed to another third characteristics or conditions for an offer to be a valid one. Third item on our list is that an offer must proceed from the right party. Very important. An offer must be proceed from the right party. And I have a locus classicus case for you here. In case of Ajayobe vs. Executive Secretary Family Council of Nigeria Limited. The citation is before your screen. What happened in this case? I'll just provide you a brief overview fact of this case. In this case, the plaintiff was called for an interview, and then on the process of the interview, the panel heard of that very interview instead of the secretary, who was charged with that duty of saying that you are hereby appointed or you are hereby accepted to work in this very company. I don't know, mistakenly or erroneously claimed that the plaintiff has been offered the job, and the onus or the duty, the person that has the onus to do this is the secretary. So it happens that the promise by the panel head turned out to be a fake promise, because he actually said, maybe after examining the person, he was like, I'm satisfied with your interview. You are hereby granted this opportunity to work in this noble company. Instead of the secretary, who has the duty to do that based on the company modus operandi, the whole thing came from the panel head. Then later on, the plaintiff instituted an action for failure or breach of contract of an employment. How can you just promise me that you have offered me a job and you later on change your mind? In fact, I have suffered harm. I have suffered a lot. I have lost my job as a consideration because I was expecting to work on this very company. What head are you talking about? I'm going to court. He maintained an action before the court, and then the court were faced with the issue of whether there was actually a contract between these people, whether there was actually a promise that has been breached between these people. Of course, you should know that contract is all about promise and breach of promise. That's why I made a video on breach of promise to marry. In case your boyfriend or that your school friend has disappointed you on the long run, Check the video above because that video is going to tell you more about breach of promise, but don't go there until you finish watching this one. So the court were faced with the issue of whether there was a contract. Then the court examined the whole fact and figure and said that there was not a contract here. There was no contract here. The reason is that in this case now, though these two parties has actually a kind of romance themselves with promise and breach of promise, in this case now, there was the offer of appointment was not proceeding from the right person that has the capacity to do that, which was Mr. Secretary. Mr. Secretary was the person, based on the modus operandi of that very company, to say that you are hereby appointed. But in this case, the offer proceeded from a wrong person. So you see why we say that an offer must proceed from the right party. I mean, if your lecturer presents you with a hypothetical question or problematic question, you should be able to examine whether the thing he's asking you is to check the characteristics of a good offer. Because if offer is proceeding from the wrong person, and of course, I missed something very important in this case. The action was instituted against the employer. So in this case, it was not the secretary that was the defendant. Neither was it the panel head that was the defendant. It was, they were suing in what we call in torts, strict liability offense, like strict liability wrong. That is what is known in law. In this case, an employer could be held liable for the employee's action. If you are not in tort or criminal law student, don't go bother yourself. I'm just trying to drive home a point. So they instituted an action against the employer. The employer has to defend himself under the ground that actually the person that made the offer was not the right person that has the onus based on the modus operandi of that company. I believe this settled the issue that an offer must proceed from the right party. See how as I'm calling authority for you, you must do so to your lecturer to earn your mark. It's not just enough for you to say an offer must proceed from the wrong party. Close quotes. My dear, support it with authority. So we proceed to another very important point, which is to the effect that an offer is different from treat. Very important. Even if you will not take away anything from what I've been saying here, make sure this very point enter into your brain. Offer is different from treat. Very important. That is where the whole question is going to come from. What is treat? What is offer? That is what we are going to consider now. An invitation to treat is a legal term in law of contract, which refers to an indication or an action inviting other to make an offer. It is not an offer itself, very important, but rather an invitation to negotiation or a begin process of forming a contract. We have defined offer before. We now consider invitation. So no need of repeating ourselves, because actually you watching this video, you don't have time. You will just leave here and go away. So we have seen that an invitation to treat is not an offer. It is something, a kind of it's just a way of you signifying your interest to invite another party to come for an offer. I will give you an example to this. An example, no need of giving you a fake example where there are many cases to do with that. A locus classicus case here is a case of Pharmaceutical Society of Great Britain and both cash chemists, a case decided in 1953. It was in that case that the full court of the King's Bench, whatever, decided to the effect that a display of a goods in a shop is not an offer, but an invitation to treat. Don't worry, I will explain. What this means that if I have decided to be selling this is pure water, right? I have produced this pure water and kept it in my shop. This is pure water. I have kept it in my shop. Then this thing is most obtainable in supermarkets. If you go to supermarket, they have a price tag for all their products. Every product in a normal supermarket have a price tag to it. So if you go there, you pick up the goods and then you go to the cashier desk or you go to wherever they are to collect the money. It is there that the real contract takes place. The real contract doesn't take place where you pick the goods or wherever in supermarket. It is in that negotiating desk is where the contract starts. So for the fact that you pick a particular goods with a price tag of so amount, when you get to the cashier desk is where the contract then will take place. So you cannot maintain an action and say that because this person display a car of 1.5 million in the car garage or where he sells a car, and therefore you have come with that amount or you transfer that amount and then you came to claim it If the person refuses to sell for that amount, you cannot maintain an action, because this case of Pharmaceutical Society of Great Britain and Boots Cash Chemist Limited has addressed the fact that a display of a goods is an invitation to treat and not an offer itself. And I have explained what an invitation of treat means. It simply means that the person is inviting you for a negotiation, is inviting you to come and make an offer. He's not, in this case, making an express offer. He's not making any offer to you. He has displayed a goods in his shop. If you go to that shop, you will then take the appropriate negotiation. That is where the real offer is coming from. You then make an offer that I want to buy this car. How much do you sell this car? Or I see this car has the price tag of 1.5 million. Please, I want to buy this car. The person can say, my friend, I'm not selling for 1.5 million. It's simply an invitation to treat. I'm selling that car for 2.5 million. So do accordingly. That was how this thing. This is just to tell you that this case illustrates the fact that a display of goods is simply an invitation to treat and not an offer itself. Then we also consider another very important thing to know concerning existence of offer. An offer can be withdrawn provided that acceptance has not been made. That is to say, you can take back your offer provided there is no valid acceptance. If an acceptance is made, if an acceptance has been duly made and you decide to withdraw your offer, what you have done is breach of contract. Yes, they will institute an action against you. Remember all these cases we have been treating, all these things we have been discussing as to characteristics of all these cases I have mentioned so far to you. All of them is to the effect that the party who made an offer failed to honor it. But the court has interpreted most of them to mean there was no offer or there was offer. That's why we are now saying that an offer can be terminated actually, or can be withheld or withhold, provided there has not been acceptance. So if I display a goods in my shop, like the case of a Pharmaceutical Society and Boots Cash Chemist Limited, if I display a goods and you came to my shop to make a proposal and I say I'm not selling for that amount, you cannot institute an action against me because there has not been an offer. What I made was an invitation to treat. Then you have come for a business, let's make the offer. That is what we are now referring to, say that an offer can be withheld or withhold, provided there has not been acceptance. A case there is case of Pine and Cave. That case illustrates the very principle that if you have the right as the offerer to withhold your offer or to withhold your offer, provided there has not been an express declaration or pronouncement on acceptance. That very case simply illustrates this principle that you can actually withhold your offer or you can actually withdraw from a particular offer provided that nobody or no party has accepted it. That is what it is. Then, on a last note, there is one important case I want you to consider. The case of Oriental Bank PLC vs. Bilante International. The citation is before you, my lord. Read up that case. It's very important if you are dealing with contract law. Then if you want more on our first video as regards to the introduction of contract law, I want you to click the link above because that video has everything you need. I will see you in my next video next week. Subscribe to King's Advocate. Thank you.